Good evening, ladies and gentlemen. I can see we have 8 people in the class now. Can you hear me?
Yes.
I can see Eric, I can see Fidel, Jean-Paul, I can see Carissa, Manzi, Umuhoza. I can also see PC and Migaiwa.
PC is Mariros.
Okay, I hope you can hear my voice. If you
Yes.
can, just answer back. Let me hear your voice too. Or alternatively, you can write it. Yes, can you hear my voice?
Yes.
Yes, I will hear you.
Okay, Sawa. Thank you, Jean-Paul. Yes, Fidel. Sawa, that is okay. So, without wasting time, let us proceed on to the business today. First and foremost, let us remind ourselves what we did last time. We introduced ourselves to company law, and we said that there's a big difference between a company and the other business organizations. And we said, for purposes of the examination, ICPAR is not interested in sole proprietorships or partnerships or cooperative societies. No, they are not. The only thing they want to know is, do you know the difference between the company and these other businesses? Do you know the advantages of forming the company over forming these other businesses? That and we said this is what we refer to as the rule in Solomon versus Solomon, and it is the rule which establishes the veil of incorporation. Then we talked about the principle of legal corporate personality. The principle of legal corporate personality, simply the principle of Solomon versus Solomon. When we form the company, what do we get? That Article 24 of the Companies Act says when a company is incorporated, it becomes a legal person distinct and separate from its members and managers. Article 24. And because it becomes distinct and separate from those who form it, it acquires certain characteristics. It acquires certain features. And we said there is distinct legal personality, there is limited liability, there is perpetual succession, there is a common seal, capacity to own, capacity to sue, capacity to contract, and capacity to borrow. These are the characteristics of the principles developed under the rule in Solomon's case. And we say that because of this, then the company is covered by a net. The company is covered by a veil. And we tried to imagine when the lady is getting married, she wears a nice dress and she covers her face. So when Peter, John, Rukundo, and Migaiwa form Company Alpha, they are covered by that net. They are covered by that veil, and we can no longer see them. Instead, we see Company Alpha. That is the veil of incorporation. And we said, yes, the veil of incorporation makes us see the company only and not those who form the company. However, if the company will misbehave, if the company will break the law, then what will happen is the office of the registrar at the company as if it is a partnership, as if it is a sole proprietor, that we are not looking at that organization as a company, but every individual, we have removed the veil of incorporation. We have moved into the exceptions to the rule in this. This company RwandaNet, just read that part B, 1 minute, just read it. Okay, so what we are saying, I believe you can hear me to know how to answer part B. In part A, we have said we are looking at the characteristics. In part A, we are looking at the characteristics. We are looking at the features. So what happens to part A there? Part A we look at this. 1 minute. Part A, we look at the features, the characteristics. This is what we look at in part A. Okay? In part A, we tell the examiner this information. This information, we tell the examiner, we get our 10 marks. In part B, sawa, no problem. In part B, we are now looking at the exceptions of part A. In part B, we are looking at the exceptions of part A. What are the exceptions of part A? We go to lifting the veil of incorporation. In part B, we go to lifting the veil of incorporation. There. Page number 6, page number 7. The veil of incorporation, the corporate shell, it is in Solomon's case. It is the one independent from those who form it. And we shall look at the company and not those who form it. In the original sense, we look at the company and not the people who form it. But now, when we look at this story of RwandaNet, we realize that the company called RwandaNet has broken the law. The company called Rwandanet has broken the law because we are being told the company is involved in fraud. The circumstances where the rule in Solomon's case is qualified are collectively referred to as lifting the veil of incorporation. So if the company misbehaves, we remove the rule in Solomon's case. If the company misbehaves, we look at the company like it is a partnership. You know, if a partnership is in business, we do not look at the people who have formed the partnership and the partnership itself as separate. No. Both the partnership and the people who have formed it are the same. They are one and the same. It is just like your sole proprietorship. You are selling Umugate and the Amata next to our house. My friend, that shop of yours and yourself, you are the same. If you have a debt, we will come for the property in the shop, we will sell. If the property is not enough, we will come for you personally and check how much do you have in your bank account, and check, do you have in Coco, and check, do you have, what else do you have? We take. So in part B, about the exceptions, we now look at the lifting the veil. Simply pick it, lifting the veil. In this part, we have 6 examples. And I said, don't worry about the differences. Pick any 6 from either of the 2 or from both. Look at this word, fraudulent trading. Fraudulent trading. Okay? In the other part, look at this word, fraud or improper conduct. What is the difference? There is no difference. So don't pick any 6 or 5. You'll be safe. In this second part that I've shown you, when you pick them, and don't give stories, my friend, simply give a sentence. And in doing that, you will have answered part B of Rwandanet. You'll have answered part B. Because remember, in part B, we are being told these guys are involved in fraud. They are involved in fraud. And we have seen examples, instances, if the company is involved in fraud, if the company is not following the company's act, if we want to know the character of the management, that is what we do. I believe I have answered your question. Yes, are we okay?
Yes, I'm okay.
Thank you. I can even hear your voice now. I can hear your voice.
Yes.
Sawa. Now, so chapter 1, don't worry, but we shall look at other questions again in chapter 1. Once we are done with chapter 2, we'll combine both chapter 1 and 2 and look at questions in detail. So we move on to chapter number 2, formation of the company. Formation of the company. Now, in this chapter, we want to understand registration of the companies, and then we want to look at 2 articles of association. The memorandum and the articles of association, they are the constitution of a company. These 2 documents are the ones which are written by the people who found the company. The people who found the company or the people who formed the company are known as promoters. The promoters come together. The promoters say, let us form a company and share profits and contribute towards running the business. Let us give the company a name. Let us buy the assets of the company. Let us pick some of us to become directors, etc. Let us write these 2 documents, memorandum and articles, and go and file them at the office of the registrar. Then they will be given certificate of incorporation. So in chapter 2, this is what we are looking at. Now, these promoters, my friend, you know, These promoters are simply Migayua, Julius, Fabrice, Peter. They are not directors. They are not. Why are they not directors? There is no company. So these are just people, these are people who have an idea. So everything they are going to do as promoters, not as directors. There is no company. So the things they do, they enter contracts, they write the documents, the things they do are pre-incorporation. Pre-incorporation meaning what? The things they do are before incorporation. It is, and you get married, you get a boy. Before you get a baby, you start planning, Bebe, when Bebe grows up, we'll take Bebe to this school, we'll buy Bebe this, we'll do. My friend, these things you are doing, Bebe is not there. So it is pre-birth. It is before the birth of Bebe. So what we are looking at this point, we are looking at forming the company before the company is there. Before the company is there. And then we are going to understand that, yes, the promoters are people who bring the idea to form a company, and they do a lot of things. They spend a lot of money. They suffer a lot to form that big company. What if there will be a liability? What if there will be a debt? Will it be the debt of the promoters or the debt of the company? We're going to look at that. And then there is this principle, the doctrine of ultra vires. At the beginning, when we started our lesson, day one, I briefly mentioned ultra vires, and I said ultra vires simply means beyond. This means beyond the past. Ultra vires means in excess of. I have no power to go and teach chemistry. I have no power to go and teach mathematics. If I go and teach mathematics, what I'll be doing will be beyond the powers that university has given me. My powers are to teach I-13 law. So the opposite of ultra vires is intra vires. Opposite of ultra vires is in vires. And if you do anything intra vires, you are protected by the law. If you do anything ultra vires, it is your own problem. Sour. Now, let us move the company. Any question? Somebody is asking? Yes, I cannot hear clearly. Okay, so promotion of the company. Promotion, when you talk about promotion of the company, we are talking about forming the company. Okay, so here we are simply saying formation of the company. The company is now going to start. That is what we mean. Promotion refers to formation. The people who form the company, they are known as the promoters. A promoter is a person who gets the idea of business. He participates in transforming that idea into a company. He will get the name of the company. He will buy the assets of the company. He will go and register memorandum and articles at the office of registrar. He will prepare those documents, and then it is this promoter and the other promoters who will decide want to be directors. The first director, Peter says, Mary says, John says. So The first directors of the company come from the promoters. They have that benefit. Okay? Now, we need to understand one thing here, that the promoter is not an agent of the company. Promoter is not an agent of the company. Why? Because the company is not there. My friend, you cannot be an agent of Alpha and Alpha is not there. You can only be an agent where there is a principal. So the promoters are acting for themselves. Also, the promoter is not a trustee of the company because the company is not there. The company is supposed to be the beneficiary and it is not there. So whatever the promoters do, they do it for themselves. Whatever Papa and Mama do before you are born, they do it for themselves. Papa cannot say, oh, I'm going to drink citro so that when my child is born, my child will be very handsome. No, 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 no. Papa is drinking citro because he likes citro. Mama says, oh, my child is healthy. Nothing. Mama, you want to, the child is born, then what Papa and Mama will be doing, they'll be doing for Bebe. So that is the same thing with the promoters. When we look at the duties and obligations of promoters, we identify that there are two levels of duties. The first level of duties of promoters is fiduciary duties. Fiduciary duties. Fiduciary talks about honesty. Fiduciary talks about maximum disclosure. Fiduciary talks about fiduciary duties. The promoters must act in good faith. Bona fide, good faith. Promoters must act in good faith. The company is not there, but what they are doing, they must do it in good faith. They must do it in the best interest of that company which will be born. Number two, promoters must keep proper accounting. They must keep records of everything they do. We went to Becca and we borrowed 100 billion. We went and bought land in Musanze. We went and bought a Prado for the company. We spent this, we did, they must maintain proper accounting. Records must be there. There will come a day they will have to present those records to the company. Then the third one, disclosure. Promoter, yes?
What is money? Explain the application of monies.
Monies. Mafaranga.
Okay.
Yeah, mafaranga of all types. Because there can be the mafaranga they have both.
Thank you.
Borrowed, there can be the mafaranga they have invest money. It's just a plural of disclosure. Promoters, you know, these people, when they come to form the company, they are human beings. We may come to form the company, and I know Fabrice has a shop. He sells furniture. Fabrice is my friend. I know Julius has a land in Nyagatare. Julius is my cousin. Now, if I decide that I want us as promoters to go and buy that land from Julius, I want us, the other promoters, that, okay, I want us, please know, Julius is my cousin, Fabrice is my friend. Let us tell the other promoters in advance if we have any interest, so that we do not do what? We do not make any secret profits. Okay? You know, it is very possible I can encourage my fellow promoters. We go and buy assets from a person I know, and I do not want to get any extra. I simply know that person. I know he does good business. I will want to get. I must tell my friends, I want us to do this. This guy is my cousin. This one is my in-law. This one is my brother. I must disclose. And then when we are going to have our meeting, we'll discuss the company meeting, the statutory meeting. We must also tell the members that, you see that Prado there? That Prado, we got it from Peter, and Peter is a promoter John's uncle. We must tell them. And then they can make their own decision whether to accept or to reject that transaction. If it happens that we do not tell the truth, there's going to be a problem. We are going to look at a case here in a minute, the sombrero case. We're going to look at this case and realize promoters did not say the truth. And what happened? They were taken to court. So the first part of the duties of promoters is about honesty. And we call them fiduciary duties. Duty to act in good faith, duty to give proper accounting, duty to maintain maximum disclosure. The second part is the general duties. General duties. My friend, this is the very simple part. General duties, these are the automatic things they are going to do. It is the promoter's company, we shall call it Rukundo Limited. It is the promoters to go for registration of the company at the registrar's office. It is the promoters to prepare the memorandum. Expenses, service of directors, they are going to pick from themselves the first directors of the company. They are going to organize the board. They are going to acquire assets of the company. So they will enter the first contracts for the company. And then when the company comes into life, the company continues. Okay? So remember, fiduciary duties and general duties, also known as common law duties. 1 minute. We have said that promoters are expected to maintain maximum disclosure. Okay? Now, let us look at the sombrero case. 1 minute. Now, we take a lease. You know lease. Kukodisha. Taking a house on rental. You take it on rent, you pay rent, you pay rent. The promoters, in this particular case, here, Ellen company, non-disclosure by promoter. So the principle that we are looking at here is non-disclosure by promoter. What will happen if they want to make profit? They want to keep quiet. They want to kubeshia. Persons who are in the process of forming a company bought a lease in the West Indies for 55,000 so as to mine phosphate deposits. So they took a lease. They went and took a house, a land on rental basis. They are paying rent, 55,000 pounds. When they formed the company, they then sold the lease to the company for 100,000 pounds. This means what? Double the amount they had spent. a fact that they did not disclose. The facts came to light 8 months later.
Recording in progress.
So what you're saying is the promoters made secret profit of 55,000 pounds. They made secret profit of 55,000 pounds. They did not disclose. When the members got to know about this, those promoters were now directors and they were removed from office. So look at that case number 6, the sombrero prophet case. Promoters are not maintaining maximum disclosure. If you do not disclose as promoters, you are making secret profit, you will be removed from office, you will be taken to court, you will be fined and can be imprisoned. So just remember that very important point. Okay? We must also understand this. It is not a must. It is not a must that promoters will become directors. There are some promoters who will say, I don't want to be a director. I'm very busy, or I just don't want, I don't want. So it is not automatic. But if they want to be directors, then from among themselves, who is going to be a director? So that is what happens. Okay. We go back. So we have said there are 2 levels. Number 1, we need to understand a promoter is not a trustee, a promoter is not an agent, because there is no company. What the promoter is doing for himself. But a promoter duties and must maintain general duties, which we have looked at. Okay. Remuneration of promoters. These guys, it is true, they do a lot of work. Without them, we would not have Company Alpha. They are the ones who have formed Company Alpha. But the law is very clear here. A promoter has no right to be compensated for forming the company. A promoter is not entitled to remuneration, and he's not entitled to recover any expenses in kind. My friend, if you spent 100 million to form Company Alpha, that is your own problem. Company Alpha did not ask you to form it. It is like this. If your papa and mama, after they give birth to you, when you are now a big guy, like Mr. Julius there, like Ntaganda, like Fabrice, they now come and they tell you, now, Fabrice, we spent a lot of money on you. Now, we want you to refund us. Will it be fair? It will not be fair. What even there? That was their own contract, their own agreement. When they went to take Fanta or Citro, they know where they got each other. They know where their friendship came from. So the same thing happens when we talk about companies, that the promoters cannot form a company and then they come and demand that the company should pay them back. Then they come and demand that, oh, they spent so much money, they suffered a lot of inconvenience, they need to be paid. No, the law says it cannot work. Why? Because when they were doing all this, the company was not there. Okay? However, the law is also very fair. The law says that promoters can make a provision in the articles of association and state that they are requesting to be refunded specified sums of money. They are requesting to be given certain benefits. But this must have been provided in the articles of association. We are going to look at this in a moment. Okay? So what you're saying is this: promoters are not entitled to this. They can be rewarded depending on what has been specified in the articles. Example, if they are going to disclose, if they are going to tell the company, if they're going to tell the members in a general meeting the truth, they are entitled to sell overvalued assets to the company in return for a profit. So if our articles allow, then what we can do is we come to the company meeting, that first meeting, which we call statutory meeting. We shall discuss it later when looking at meetings. And we tell the members, Sawa, we took this lease for £55,000. But we now want to sell it to the company for £110,000. We want to make a profit of £55,000. Can the company accept? If we have made that disclosure to the company, the members are there and they have looked at what we have said. The members have the power to decide yes or no. And this is what should have been done in the sombrero case. Had they disclosed, then the promoters are also free to sell. Yes, please.
Yes. What is
Yes.
overvalued asset?
Overvalued asset. We bought the asset at £55,000.
Yes.
We are now selling it at £100,000. We are selling it more than, yeah.
Okay.
Yeah. We are selling it more than the actual value. Yeah.
In that at that.
Yes.
At that time, promoter can be rewarded.
Yes, on condition that there is what? Disclosure. In the company meeting, the first meeting, the members there, yes. Do you see that Prado? We bought it at 55 million, but we want to sell it to the company at 70 million. Do you people accept? If the members accept, sawa. Members can bargain, can say, no, we cannot sell it to you at 70 million. We will sell it to you at 65 million. So whatever we agree, no problem. But it is about what? Disclosure. Okay? Another one. Instead of asking for money, instead of asking for cash, we can sell overvalued assets to the company in return for fully paid shares. We tell them, Sawa, £55,000, but we are selling it to you at £110,000. We want fully paid up shares of 55,000. If they agree, Sawa. Another one. Promoters are the people who entered contracts. when the company was not there. So they know many organizations out there. They have already done business with Becca, with the Coget, maybe they bought the model car business with. They can come and tell the company in the meeting that, Sawa, we are the ones who know these business people out there. We want the company to allow us to act as the company's agents. We shall be doing business on behalf of the company, connecting the company with those other people, but we want a commission. And the commission they disclose, you want 3%, 4%, whatever it is. So promoters can request for a commission to act as agents of the company. If the members agree, no problem, promoters can get that. Next, it is always the practice that promoters are allowed to take extra shares at par value. Extra shares at par value. You know what we mean by that? We are selling shares. We have floated shares in the market. The shares are going for 10,000 per share. After 1 to 2 months, our business is doing well. The shares are now going for 18,000 per share. The promoters can be given an opportunity by the company to take up the extra shares which will be there at when the rest of the Baturaje are buying shares expensively at 18,000. We, the promoters, will be allowed to buy shares at the original price of 10,000. That is another way promoters can be remunerated. Another one, traditionally, promoters are either given deferred shares, founders shares, or management shares. What type of shares are these? Deferred means after other shares have been offloaded, after other people have been given shares. Deferred means future. Any shares that come up later, we can give the promoters. A promoter is a founder. They are the ones who started the company. They can be given founders' shares. Promoters, on many occasions, become directors. If they become directors, they will then get management shares. Okay? And then the other thing which happens automatically, under normal circumstances, promoters are the first directors of the company. So the law is this. The law is that a promoter should not be compensated. A promoter should not be rewarded because there are exceptions. If in the articles of association, we have put a statement or statements that promoters can be given founders' shares, promoters can be given a commission, promoters can be given extra shares, promoters can disclose and sell overvalued assets, my friend, promoters will get that. So promoters are taken care of. They are taken care of, but they must not share, they must disclose, and they must request. It is not automatic. They must request at the statutory meeting. Examiner will ask you, is a promoter? Your answer is no. A promoter is not entitled to get a reward. Why? Because there was no agreement between him and the company. The company was not there. And then the examiner will ask you, are there exceptions? You tell the examiner, yes, there are exceptions. If the articles of association allow, promoters can get, and then you mention this A, B, C, D, and you are good. Any question, ladies and gentlemen?
Yes, come with the B. Explain B.
This one.
Yes.
Okay. When you look at A, they are selling overvalued assets in return for a profit. So they will get the actual mafaranga profit. When you look at B, it is the same thing, but they do not want actual mafaranga. They want fully paid shares. So instead of getting 55,000 pounds in cash, they want to get shares worth 55,000 pounds. Okay. So the first one you get cash, the second one you
get shares. Okay.
You get shares worth that cash. Sometimes you may save it, but if you give me the equivalent of shares, you know it's going to be an investment. Yeah. That is the story.
Thank you.
Okay. Now, welcome. Now, pre-incorporation contracts. Pre-incorporation means what? Before the company is incorporated, before the company is formed. The contracts which the promoters entered before they had been given the certificate of incorporation by the registrar. Those contracts which promoters entered before they were given certificate by registrar, those were not contracts of the company. The company was not there. Those were contracts of the promoters. Promoters are not cleared, my friend. That is not the debt of the company. That is the debt of the promoters. Let us look at Kellner versus Baxter. Let us look at this case. 1 minute. Very simple, straightforward case. In Kellner versus Baxter, this is case number 8. We realize that promoters one minute. We realize that pre-incorporation contract is the principle that we are looking at, and the case is Kellner versus Baxter. Now, promoters of a company signed an agreement on 27th January. They signed an agreement on 27th January for the purchase of goods on behalf of the company, which had not yet been incorporated. The company was thereafter incorporated on 20th February and subsequently became insolvent and was liquidated before paying the debt. So the company became broke before it cleared the debt. Remember, promoters take the loan on 27th Jan. The company is then formed almost 1 month later on 20th Feb, and then the company goes broke before clearing the debt. Now, the main problem now was who was going to pay this debt? Was it going to be the company or was it going to be the promoters?
The promoter.
Yes. And the court said that the promoters were personally liable because at the time they took the loan, the obligation of the promoters and not the obligation of the company. That is Kellner versus Baxter. And this is about what? Pre-incorporation contracts. Okay. So when we look at a question, a case study question, let us look at the date. The company formed? When was the debt incurred? If the debt was incurred before the company was formed, that debt is not a debt of the company. That is a debt of the promoters. And that is based on Kellner versus Baxter. Okay? So, that being the principle, we then look at exceptions. One thing I told you, my friends, on day one is this. company law has very interesting rules. The rules are quite strict, but what happens is there are exceptions. You have seen about promoters being given a reward. The rule is looking strict, but they are given a reward if the articles allow. Another exception is this, that when promoters enter pre-incorporation contracts, the rule is strict that that contract is a contract for promoters and not the company. However, there are instances where this will be a debt of the company, which we are going to look at in a moment. Okay. Now, what is the justification? Rules governing pre-incorporation contracts. If you look at these 6 points here, they are talking about the same thing actually. That before incorporation, a company does not have legal existence, and therefore it cannot enter a contract, it cannot have agents. So these promoters are doing things on their own. Okay. The second one, a person who pretends to enter a contract as an agent and there is no principal is entering that contract personally. So if I pretend I am entering the contract as an agent of Bradirua, and by that time, Bradirua has not been incorporated, my friend, I am entering the contract as my, not Bradirua. If you are not existing, if you are a ghost, you know what a ghost is? If you are not in existence, if you are not there, if you are just air, you cannot enter a contract. A contract cannot be entered by a non-existent person. So we cannot say it is the contract for the company. The company is not there. Okay. I hope everybody has managed to enter the class now. The next, that, do you know what ratification is? What is ratification? Ratification. To ratify is to give authority to something after it has been done. That is what ratification is. I am a driver. I am your driver. The model car from Chigali to Nyagatare. There is another driver. His job is to drive another vehicle from Chigali to Musanze. And then, yesterday, I drove the vehicle from Chigali to Musanze, and that is not my duty. So what I have done is ultravirus. I drove the vehicle from Chigali to Musanze. I only have authority to drive the vehicle from Chigali to Nyagatare. I did this yesterday. Then today, I come to you and I tell you, boss, I am sorry. Please have Mbabazi on me. I drove the vehicle from Chigali to Musanze instead of Chigali to Nyagatare. Please have Mbabazi. And then you tell me, sawa, it is okay. That is ratification. So ratification is you have Mbabazi and you tell him it is okay after he has done something he was not supposed to do. And the law says, if you say sawa, it has been done, then it means you allowed it to be done. Okay? So the pre-incorporation contracts to become a liability of the company is under Article 49 of the Companies Act. In Article 49, what we are told is this: a pre-incorporation contract is enforceable by or against the company if after incorporation, the company enters agreement. So number was, you know what? Last week we did this and this. Yesterday we did this and this. The members then say, Sawa. And they authorize the company, you are now in existence. Can you now go and enter the same contract with Becca? So the company takes over the contract which was with the promoters and enters the same agreement. And now the company directors sign. Now that will be a contract for the company. If you do not do that, my friend, that one is a contract for the promoters. They must face the liability by themselves. Okay. Any question, ladies and gentlemen? Okay.
Come to number 6.
Number 6. Now,
Yeah.
okay. First and foremost, in order to understand number 6, we need to look at number 4 and number 5. Number 4, a contract cannot be ratified by a company after the company has been incorporated. A contract cannot be ratified by the company itself cannot say sawa and then everything is fine. No, it cannot. It must be that this contract, first of all, told about it in a general meeting. The members say sawa because the members are the owners of the company. Once the members say it is okay, the members then authorize the company management to accept that contract. When they authorize the company management to accept that contract, now that is ratification. So it must come from the members. Tell the management, then follow the instruction. The same management must now go and enter the same contract which the promoters had entered. In other words, the promoters entered a contract with Becca for 100 billion before the company was formed. The promoters then came and disclosed to the members in the general meeting. The members then said, sawa, it is okay. The members of the company, we have accepted that obligation of 100 billion. Now, go to Becca and enter the same agreement with the Becca, you now as the company. Because the people who entered were simply promoters. Now you go and enter the same contract and backdate it. Backdate it to the date when the promoters entered. Now, this is what number 6 is telling us, and this is what Article 49 tells us, that you must enter the contract with the promoters. Then it will now be, yes, the company has entered the contract. Okay. Sawa. Now, what happens in case promoters misbehave? Remember, we have said promoters have fiduciary duties and promoters have general duties. What if they do not obey those duties? There is no disclosure, there is no accountability, there is no bona fide, honesty. What if they fail? If they fail, then the company or any person who has been affected will have the right to do any of the following. So these are the things we can do against the promoters. Number 1, rescission. What is rescission? Rescission is simply canceling the contract. So we refuse the contract. We say that contract, we don't want us themselves. That contract is not a contract for the company. We don't want it. That is rescission. So we cancel the contract. Number two, we have the right to go to court and demand for an action of account. Action of account is what? We want records. We want records and we want to recover profit. So we want them to present to us a clear record of everything that they did. How much did they spend? Give us back that money, the profit that these Batulaje have made when they tried to Kobesia. Then the third one is damages. Now, damages are different from the fourth one, which is compensation, in the sense that with the damages, it is a punishment awarded by the court because you have broken the law, and the court will decide how much it is. Being paid because, being punished because you have broken the law, and it is the court to decide how much it is. Compensation, on the other hand, you are given back exactly what you have lost. If you lost 10 million, you are paid back 10 million. If you lost 50 million, you are paid back 50 million. Damages is because this guy broke the law, this guy must be punished to pay a specified sum, which the court will decide. So the court will decide damages plus compensation. The court will decide this. If example, there is somebody disturbing us here. Mr. Julius is disturbing us now. Okay, now let us look at it this way. If you are driving your motor car and then somebody else is driving his motor, or another motor car, and he comes on your side and he hits your motor car, pay damages, which the court will decide. Okay. Apart from that, when this guy hit your car, he broke the headlights, he broke the windscreen. Now tell us, how much is the headlights? How much is the windscreen? Then you tell us, oh, it is 30,000, 300,000, whatever it is. You will be paid that 30,000 or the 300,000 or the 50,000 or the, so compensation is the exact, you broke my telephone. How much is my telephone? 100,000, my friend, 100,000 you must pay me. Number two, because you broke the law by breaking my telephone, you must be punished, damages, and the court can say any amount. Simply for purpose of what? Punishing you because you have broken the law. So there is a difference between damages and compensation. Then public examination. When we talk about public examination, these guys were not doing this alone. They went to Bekao, they went to Koje, they went to Toyota Rwanda. They went to another office here and there. The case will go to court. People will be called, witnesses, to come and give evidence. That is what public examination is. Yeah, of Becca to come and give evidence. The person selling the motor car at Toyota Rwanda to come and give evidence. That is the public examination we are talking about. Action of account is simply a case asking you to give a proper record of your transactions. The word action means going to court. Action means going to court. So going to court to give a proper detail of how the money was spent. If there is any secret profit, we want to recover it. The company is entitled to recover any secret profit made by a promoter in his promotional activities without disclosure. The things they were doing without disclosing to us, we are now going to call witnesses in court. The court is going to ask the witnesses, present records, present evidence. You want to see vouchers, you want to see all those transactions. And when the court realizes, you made a secret profit of 55,000 pounds, my friend, you must pay back that secret profit. Okay, that is the position. So we are done with promoters, unless you have any question. A promoter is that person. A promoter is not an agent because there is no principal. A promoter is not a trustee because there is no beneficiary. A promoter is acting for himself, even though we know he's going to form the company. Whatever the promoter does is pre-incorporation. It is before incorporation. The promoter has two levels of duties: fiduciary duties and general duties. Fiduciary duties are the duty of disclosure, the duty of being honest, and the duty of accountability. General duties are the ordinary things that he's going to do: getting the name of the company, buying the first assets of the company, becoming the first director of the company. Those small things that they must do, those are the general duties. Promoters do not have the right to be compensated or to be rewarded because there was no agreement between them and the company. However, the general practice is that if our articles of us or that, then they will be given this or that. And this is very simple. Remember, it is the promoters who are going to write the articles of association and the memorandum of association. So they are going to protect their interest. They are going to write in the articles that promoters can get deferred shares, promoters can get sell overvalued assets for a profit, promoters can become first directors. They are going to write in the articles in the beginning. So when they come to the general meeting and they present this to the members will look at that, and there are very high chances the members will accept on condition they get that compensation. Then the last thing on promoters is what? When promoters enter a contract, that contract is not the liability of the company, it is the liability of the promoters. Why? Because the company is not there. When Papa and Mama are yet to get the baby is still en veine sa mère. Papa and Mama cannot put an obligation on the baby because the baby is not there. The baby was not part of their agreement and whatever they were up to. Okay? It is only later in life, it is only when the company has now been formed and the promoters come and tell the company, oh, you know what? We did this and this. And the company then accepts and ratifies. And then it enters the same contract with that other person. Then the liability becomes the liability of the company. As simple as that. So, ladies and gentlemen, that is the position concerning promotion, concerning promoters. Okay? Our next level now is to look at the documents, the important documents which must be written by the promoters in order to be formed. Okay, and very simple. I will use a shortcut. We are almost ending the 40 minutes, so It will go off in a minute, but don't worry about that. So the two documents are the Memorandum of Association and the Articles of Association. Those are the two documents. The Memorandum of Association and the Articles of Association. They are the constitutive documents. They are the constitution of the company.
Recording in progress.
Subira inyuma. Uri gukora.
Please, we don't hear your voice.
I'm waiting for more people to join. I'm waiting for more people to join.
Okay, thank you.
Yes. Okay, so a simple explanation concerning Memorandum of Association and Articles of Association, and then we shall go into the details. When you look at the screen, you find there is MOA and AOA. MOA is Memorandum of Association. MOA, Memorandum of Association. AOA, Articles of Association. Okay. Now, I will make it brief and then we look at the details. When you look at the two documents, they must appear. They must appear in order for a company to be registered. The Memorandum of Association is superior to the Articles of Association. The Memorandum of Association is the main document that is used to register the company. Now, all companies must have Memorandum of Association. All companies must have Memorandum of Association. Memorandum of Association is aimed at the outside world. It is, and we are saying Memorandum of Association is the main document of registering the company. It has clauses. Clauses are simply paragraphs. It has clauses. Clauses are paragraphs. Now, when a transaction is ultra vires the memorandum, it cannot be ratified. If anything goes against the memorandum, it cannot be ratified by the general meeting. And then lastly, If there is any conflict between memorandum and articles, so the memorandum is the main document. Memorandum is aimed at the outside world, to the prospective investors. It tells the investors what we intend to do. It has clauses, it has paragraphs, and those clauses or paragraphs, we're going to look at them: the objects clause, the liability clause, the association clause. And then, if a transaction is against the memorandum, it cannot be repaired. It cannot be ratified. If a transaction is against the memorandum, it is fini. Nothing can be done to it. Then, if there is any conflict between memorandum and articles, memorandum will prevail. Sawa? Now, all companies must have memorandum. Articles of association. Articles
Please.
are secondary to
Lecturer.
memorandum. Yes.
Come to number 3. It is aimed at the outside of what?
Outside world. A memorandum is to
Yes.
be given, it is to be given to the prospective investor. Do you want to invest in a company? Given the memorandum, you at it, then you will know what does our company do. Outside world. The opposite is this. Articles of association, article of association is for the management of the company, for the rules and regulations of the company. But memorandum is for the outsiders, yes. Then,
Yeah,
a very important thing is this. All companies must have a memorandum, but the New Companies Act says that a company may or may not have articles. You can write your articles. If you don't want, forget about it. It is not a must. It is not a must. But now there is a problem. If you decide in your company that you do not want to have articles, then what happens is the Companies Act becomes your articles. That memorandum, every company must write its memorandum. Articles, if you want, you can write articles. If you don't want, don't write them. If you don't write them, the Companies Act becomes your articles. And let me tell you, public companies, all public companies write their articles. Private companies can decide not to write the articles, and they will use the Companies Act as the articles. When you use the Companies Act as articles, you are putting yourself in risk, because the Companies Act must be followed 100%. And it is a big document. Okay? Then, the articles of association, if there is a transaction that is ultra vires the articles, it can be ratified by the general meeting. If there is anything that is, you can say, Sawa, let us change this. But if something is ultra vires the memorandum, my friend, it cannot be ratified by the general meeting. It becomes fait accompli. It is useless, it is zero, it is nothing. And then,
Excuse me, sir.
Yes, please.
Is the article of association be compared with the policies of the company?
Not exactly, because a policy document is not registered at the office of the registrar. A policy document is about the what? You look at the organogram, the top level, the middle level, about discipline, about the charter, yeah, about the, what do you call it? There's this thing also you call the what? the mission and the vision. That is what the policy document will concern. But the article is bigger. The article is bigger than the policy document. The policy document will fall on the side of the article. Okay. Look at this. Yes, an example is this. In our company, we may have a policy that says all employees must be in their office by somewhere in the morning. That is a policy. That one cannot be put in the articles. A policy can also be that in our company, every Friday, all employees will come dressed in. In our t-shirts, having the logo. That is the policy, but it's not in the articles. Okay. So then when there is a clause and the memorandum is superior. Okay. So simply, that is the position. That we have the two documents, the memorandum of association and the articles of association. These two documents are the constitution of the company. Memorandum must be written by all companies. Articles, you may or you may not write it. Okay?
Excuse me, sir. Excuse me, sir.
Yes.
May
Yes,
you
please.
give us
I can hear you.
hello?
Yes, I can hear you.
May you give us a transaction where it can go beyond the powers of MOA?
A transaction going beyond the powers of MOA. Okay, Sawa. When you look at the MOA, we are going to look at the clauses. A clause is a paragraph. The MOA will give the objects of the company. You know objects, the objectives, the purposes of the company. Now, if the purposes of our company are to build roads, and then we start constructing houses, it is against the memorandum. Our company are to build hospitals, and then we start education facilities, schools, it is against the memorandum. So when we go to, in just a minute, when now we look at this, when we look at the documents themselves, let us go to the memorandum of association. Emmanuel, you are making noise to the rest of the class. When you look at the memorandum of association, one, it gives us the name of the company. The memorandum gives us the name of the company. The memorandum gives us the register of the company. The memorandum gives us the objects of the company. Now, if our objects are to do alpha and then we start doing beta, it is against the objects. It is null, and our company name is alpha. It is written in the objects. And now we are using a name, Indigo. My friend, it is against the memorandum. A company cannot be registered without the memorandum. Every subscriber to the memorandum, these are the promoters, they must sign that document so that they will be bound by that document. We also have limitation of liability. Is our liability limited by shares or by guarantee or by both? We also have the capital clause. What is our nominal authorized capital? So when we do not follow any one of those clauses there. It is against the memorandum, and it cannot be adopted by the general meeting. It is finished. We have to go to the registrar. We have to write another one afresh. Okay. Now, a detail on the various clauses. Yes. Yes. Jackie is asking if we can all mute. If you can all mute, then it will be good. We will not disturb the other students. I think it is fair. Yeah, Jackie is the name clause. We have already decided that our name is Alpha. We have already decided that our name is Rukundo. We put that name in the memorandum of association. Why should we now change our name without going to the registrar, following procedures of changing the name? If we don't do that, it is against the memorandum, and in fact, we should be punished by the registrar. Article 37 tells us that the name we are going to choose should not be against the law of Rwanda. The name we are going to choose should not be misleading. Now, already there is company Rukundo Limited. We also want to have our company called Rukundo. It should not be similar to another existing name. It should not confuse our company with another company. It should not be having bad morals, talking about bad things, talking against the government. If it does not comply with this, my friend, we are in trouble. In fact, this is one of the areas where lifting the corporate veil will be done. The promoters will go and reserve the name. You give the registrar, I think it's about 30 days or so, to reserve the name so that the registrar can look at your name. You give 3 choices. Look at the name or names and ensure that they are not similar to other existing names. Okay, now change of name. You are allowed one chance. You are allowed one chance to change your name. So if when you are forming the company, you call yourself Rukundo Limited, but after some time, you have decided Rukundo Limited is not good, you are given an opportunity. Change your name to another, but you follow procedures, you go to the Registrar General, and you present that new name. That is voluntary change. Compulsory change will happen if your name has been refused by the registrar because it looks like an already existing name, okay? It looks like an already existing name. You want to call yourself Bradua. Hey, Bradua 1, you want to confuse us with the Bradua which we know so well. Registrar will tell you, my friend, this one, forget about it. Your name is against the law. The government does not want that name because it is a name which is bringing some bad feelings. It is causing confusion. Then it is compulsory change of the name. And compulsory change of name, the registrar can ask compulsory as many times as possible. Voluntary, you are given one chance. Compulsory, as many times as possible. Okay. Then, once your name has been accepted, it will be published on your offices, on your buildings, in your letterheads, in your notices, in your checks, invoices, and all other official documents. Failure to publish your name, lifting the veil of incorporation. The veil of incorporation will be lifted if you do not publish your name on your registered office, you do not publish your name on your invoices, on your checks. It is an offense. The name must also be put on the common seal. The name shall be put on the common seal. You know what the common seal is? The stamp of the company. Who has contract with another business? The director's sign of the company on that document. Your name must be on that company common seal. Okay. Registered office clause. You must have a registered office in Rwanda. You must show us that the registered office is situated in Rwanda. In which town? Is it in Musanze? Is it in Kigali? Is it in Hudare? Where is it? It must be very clearly known. You cannot have two registered offices. Registered office is only one. Okay? But the head office can be different from the registered office. A registered office will simply be the office which you have put in the document as the office you have registered your company with. And in the course of time, you may decide head office is now in Changu. No problem. That is where the director is. That is where the company secretary is. No problem. But your registered office is actually in Kigali. There is no problem with that. Okay. Now, it is the registered office. To the registered office, all communication of the company should be sent there. And it is at the registered office that all the important documents of the company, the articles of association, memorandum of association, the minutes when you have meetings, every relevant document of the company must be kept at the registered office. However, I have said the registered office can be in Changugu and the head office is in Kigali. If your company secretary is always in Ghana, these documents will be kept where your company secretary is. The documents are supposed to be where the company secretary always is, because it is the company secretary who shall be the custodian. He or she is the one who is in charge of keeping and maintaining these documents. Okay. Sawa. The members of the company, the shareholders, and any person who wants to do business with the company has the right to give notice to the company secretary and to request to look at these documents. Okay. And then we have this important clause, the objects clause. This is a very important part because of this. The objects clause protects people who want to know the purposes their money will be used for. I want to invest in the company. What will my money be used for? Oh, the company deals in manufacturing and selling amata. So I need to know, what does the money that I put into the company do? The objects clause will tell me. The objects clause also helps us to know the powers of the company, the extent of powers of the company. And that is where now we have what? The ultra vires doctrine. That if our powers are to do one thing and we start doing things beyond those powers, that's ultra vires. There is the case of Ashburn, Arridge, and Iron. 1 minute. In this particular case, we understand how serious the ultra vires doctrine is. Okay, 1 minute. So the principle here is doctrine of ultra vires. The object in the memorandum of association empowered the company to sell, lend, or hire railway carriages and wagons. The company then contracted to build a railway line. The court ruled that the contract was ultra vires the memorandum, and therefore it was void. So if in our memorandum, the object, we say we are going to manufacture laptops, and instead we start buying and selling Amata, my friend, it is ultra vires, and we'll be in serious problem. Okay. Somebody is asking about B. B, to protect persons who deal with the company and who can understand from the company the powers. That is actually about this ultra vires now. This is about the ultra vires. People has power only to build a railway line. The company does not have power to manufacture laptops. So they should not tell me that they are going to manufacture laptops. The doctrine of ultra vires, it means beyond the powers. A company must always act within the powers it has given itself. The Companies Act 2021 tells us that we should always be careful when we are writing the memorandum of association. Do not limit yourself. Do not lock yourself into a certain situation where you cannot play around with the objects. Okay? So what the promoters do when they go to a good lawyer, a good notary, they are told, let us not close our objects completely. Let us put things which are similar or connected to the main objects. Okay? So if we are talking about a matter, to be safe, we will not write our objects are buying and selling a matter. No, we are locking ourselves. We will talk about harvesting, buying, processing, transporting, selling, purifying, you make it such that even if I buy a matter from cooperative, you are still okay. Even if you're going to transport a matter, you are still okay. Things concerned with that, including other animal products. So you also find a way of putting in meat. You find a way of putting in so many other things that will open up your objects. Otherwise, if you just write one thing, my friend, you are finished. That's why we are told that that the courts regard such things as impliedly within the company's powers unless they are expressly. We say indirectly, it is protected. But if you say something expressly and you say, we are not going to do this, my friend, that is your problem. That one now, you cannot go beyond, and you'll be locking yourself in a type of business which, if that business does not do well, then you have no plan B. You must go back to the registrar and change the memorandum, and that requires a general meeting. You require a general meeting, you require a resolution, then you go and change the document. Okay? So we can always alter, we can always change our objects. There is no problem. We can change our objects so that we conform to the new businesses. We can change our objects so that we do our business in a more economical or more efficient manner. There is no problem. But there is a requirement that this must be in a general meeting. There must be it must be registered. The registrar must give that authority. Okay. So the next item then, it is the liability clause. That's our liability. When you talk about the liability, we are talking about, is our limitation by share or by guarantee or by both? We must specify in our memorandum. Okay? That we have agreed to take up 100 billion shares divided into 1 million or 5 million, whatever it is. Now, we show ability. Is it limited by, is it limited by guarantee? Okay. Then I hope and believe that at your free time, you'll go through the notes now to understand it better. Then when there is a problem, there's a question, you come and you ask so that I can clarify even more. Okay. So we talk of liability clause. Is it limited by share? Is it limited by guarantee? Is it unlimited, or is it both by share and by guarantee? Alteration of objects means changing the objects. We are selling amateur. What if we realize the amateur business is not doing well? We now want to start selling Fanta and Citro. We now want to move into a different type of business. So we are saying a company may by special resolution change the articles, the objects. Passing a special resolution, we can decide, okay, from today, we no longer want to sell amateur, or we want to sell amateur plus we also want to sell vitungulu and whatever else. We can always change, but it must be special resolution. Special resolution, we'll be talking about these resolutions. Special resolution, we are talking about minimum 75% of members saying, yes, let us change. And then we must register this. Then the registrar allows us to do any other business that we have decided to do. So this helps us to do things economically, helps us to be more efficient. It helps us to combine the business we are doing with other businesses, because what we want is to get the best. It helps us to connect our business with other, etc. Okay. It helps us to increase or reduce our areas of operation. So maybe we were situated in Musanze. We want to move not only in Musanze, we also want to go to Butare. So we can always alter, change. To alter is to change, to modify, to amend. That is what we are talking about. Okay. And capital loss. This is the share capital of the company. The share capital of the company. The number of shares that make up a share, the number of shares that make up the capital of our company. The names of the shareholders, that is the capital clause. We need to state our capital clause 100 billion divided into this number of shares. We are then able to know what is the worth of the company. We are then able to know if the company is doing well or the company is sinking slowly by slowly. Okay. Sawa. Then association, it is your sentence. Association clause, it simply says that we, the members whose names have been written here, agree to take up the shares in the stated capital and and to do the business that we have provided, we have stated. So it's simply one sentence usually, that we agree to take the number of shares in the company as set opposite our respective names and to do the business that is in our objects. 5 main clauses, okay? Let us go back here. There are 5 main clauses which must exist. 5. Name clause, registered office, objects, limitation, capital. Okay? Those are the 5 main clauses. If you want, you can add as many other clauses as possible. That is your own problem. What you'll be doing in law, we say, you'll be making a big rope to hang yourself with. The more clauses you put, the more dangerous it is for you. So under normal circumstances, the 5 are good enough. But if you want, my friend, we are told you can add as many clauses as possible, but you will be committing suicide because you are now opening room for people to come and argue, room for people to start bringing problems. The fewer 5, the better. Okay? So that is the memorandum of association. Just take your time, look through it, and ask, and we'll sort it out. Then in our next lesson, we'll go to articles of association. We shall look at Article 21. And once we are finished with this, then we are done. We are done with that area. Okay. Then we'll go to we look at a few questions for chapter 2 plus chapter 1, and then we go to chapter 3. So that is the position. What is left for chapter 2 is very small, articles of association. Okay, so we're going to end our lesson there at the articles of association. Any question? Because it is 3 minutes to the 40 minutes of the Zoom. So if it ends, then we'll spend some time. Yes?
Are these 2 documents, MOA and the AOA, confidential to the company, or anyone can read it?
They are public documents. They are public documents. They are documents which should be available to any person who is a member of the company or any person who wants to deal with the company.
Okay, sir.
Yes. When you look at this, memorandum and articles shall state the objects of the company, to protect subscribers who learn from the purposes of the company, to protect persons who deal with the company. They are public. They are public documents. They are, any document which is registered and any person who's dealing with the company, whether you are a shareholder or you are an investor, you are a lender, Beka, Koje, KCB, you are entitled to look at those documents so that you can know, does the company have these powers to do this thing? Is the company registered in the first place? Is this the name of the company? Are these the directors of the registered capital? Where is its registered office? All those things. So they are public documents. Okay. So we end our lesson there. If there's not a question, then we shall proceed Saturday at 1 o'clock up to 5, then 5:30 up to, is it 9 o'clock? Thereabouts.
Please.
Okay, so yes.
I'd like to suggest, if it is possible,
yes,
to underline for every chapter the question that can be asked in past papers. It can help us to, as you did in Amategeko, a Companies Act.
Okay, sawa, sawa. We're going to do that. As we continue looking at questions, we're going to do that. Don't worry.
Thank you.
Okay, sawa. Okay, so ladies and gentlemen, let's end the class there. We meet on
Thank you,
Saturday.
sir.
Thank you, sir.
Thank you, sir. Thank you.
Okay.
Thank you.
Okay, welcome.